The Rhode Island Foundation, partnering with passionate Rhode Islanders to lead, transform, and inspire our state. Learn more at rhodeislandfoundation.org.
Welcome to another segment of In Another Opinion, a public information program where our discussions are focused on the communities of color in the state of Rhode Island. I'm your host, Peter Wells. My guests today are the Honorable Judge Edward Clifton, retired, and Michael DiLauro, Esquire, Assistant Public Defender in the state of Rhode Island. Michael is also the Director of Training and Legislation and is the liaison for the state of Rhode Island. Today's theme, does Rhode Island's criminal justice system need reform from top to bottom? Gentlemen, thank you for being on the show today.
Thank you, Peter. How are you?
Thank you.
Criminal justice reform is something that's being discussed all over the country. And here in Rhode Island, we have our challenges as well. My first question to you is, do you agree that the criminal justice system in Rhode Island needs reform?
I do.
And when you say you do, tell me why.
I think you have to start from a look back to how this system was created, not in its inception, but how it evolved. And many of the things that are still in place today have been in place for a number of years, which have resulted in too many people having criminal convictions, records on that they are unable to get beyond. Some of the laws that we have, the legislature has passed, and have been draconian in their sentencing mandates. So a lot of these things have not been addressed for a long time nationally as well as locally, and I think it's wonderful that we're finally taking a good look at it from a number of different perspectives.
What's your opinion, Michael?
Well, I agree with Judge Clifton. I think that, maybe backing up a little bit, that any creation of mortal men and women such as our criminal justice system, that periodically it is a good thing to step back and take a look at how it's working and how we can improve it. In our current time, whether that conversation that we need to have, whether it's driven by financial concerns or by basic concerns of fairness, I don't think really matters. What matters is that we have a moment in time where we can address some of these things. I'll just share with you a real quick anecdote. I'm preparing for a presentation I'm going to do next week on the John Gordon case, which I was involved in. Was very, very fortunate to be involved on the sidelines in having Mr. Gordon pardoned after 166 years after his execution by the state of Rhode Island. And one of the things that I talk about in that presentation is the changes that have been made since that time to our own that have really improved things. That doesn't mean that we stop. We don't stop. We're obliged, I think, as lawyers, as policy advocates, as those with insight into how the system works, I think we have a responsibility to bring those things to bear and trying to improve things.
Very good. Well, I think that my experience in talking with citizens of Rhode Island is that the public feels there's a need for reform. How would you address reform if you were the magic wand and you had your withers? How would you address that, Judge Clifton?
I think I believe we need to start first at looking at how some of the laws are adopted. If we go back to, I think we need to recognize, first of all, that not that Washington, D.C. politics and policies necessarily drive what states do or don't do. But I think they have a tremendous amount of, they add and lend credit to what's going on there. So when we look at some of the laws that were passed in the 1980s that have now been deemed by some to be draconian, that led to these the disproportionality between sentencing of powdered cocaine, crack cocaine, So that started in the federal system, but then it kind of lend itself over into the state system and many other offenses likewise, some of the gun laws, these things. So I think we need to take a moment, examine the situation, the environment that gave rise to this, and also to our own adaptations of what was going on in Washington, and look back and just ask ourselves some number of questions. Number one, have they been effective? If they have not been effective, then why do we leave them on the books? I'm concerned, as I'm sure many other people, your audience are concerned, Mike as well, is that there are so many people. Let me back up. One of the basic issues with respect to sentencing is that you are to try to deter the individual as well as society from doing the same offense. I'm questioning myself, and I think others are questioning, whether or not the minimum sanctions, the minimum punishments with respect to gun thing are really acting as a societal deterrence. If it were, in fact, a societal deterrence, I think there would be less gun violence that is going on right now. I think that there is actually more gun violence going on right now. And some of the people that commit these crimes, they need to be punished. I'm not saying that they should be excused. They need to be punished. Absolutely. But must they be punished to the extent that the laws mandate right now? I think it's a time that we need to examine that.
Michael, you spent a great deal of time on the Hill, channeling legislation for the Public Defender's Office and i.e. for the citizenry. How would you address reform?
Well, I agree. I agree with Judge Clifton. I think that in some respects in Rhode Island we've been fortunate. Judge Clifton spoke about mandatory minimums and the war on drugs back in the 1980s. At the federal level, I think resulted in handcuffing judges in the type of sentence that would be fair and just in a particular case. And we've seen some movement away from that. There are many states, New York is a great example, the Rockefeller drug laws, where what we did as a people was to say, we don't trust our judges and we don't trust the system, so we're going to tie their hands. In Rhode Island, we don't have, fortunately, a whole lot in the way of mandatory minimum sentences, and our judges have a lot of discretion, which we think is a good thing. But in the cases in which they do not, they're just whoppers. And Judge Clifton mentioned one of those, the gun offenses, which are a judge's hand is tied. And really what that does is you have, rather than the judge, you have the prosecution through their charging decision making the decision about what an appropriate sentence is in a particular case. The other aspect of this is, and while we, as I said, don't have a whole lot in the way of mandatory minimums, we do have a brutal probation system in this state, where our probation system is really the cog in the machine of the criminal justice system that drives the entire process. And so, of course, probation wasn't designed to do that. Probation was designed to assist in rehabilitation and reentry. Right. And what we've done here is turn that on its head and just say, we have 1 in 20 men in Rhode Island who's on probation, 1 in 6 men of color in Rhode Island on probation, and that's what drives the process, which is really was not what it was designed to do.
So what changes would you suggest? Would you advocate for?
Well, we've been talking for the last more than 2 years now about justice reinvestment, and Judge Clifton has been intimately involved in that, and it's something that has been heard in our General Assembly. Now this is the second year, For 2 years in a row, the legislation passed the Senate Judiciary Committee and the full Senate unanimously, and it has not moved in the House. We're cautiously optimistic that that will change this year, but the extraordinary thing about justice reinvestment, which is a package of bills that would address many of the issues that we're talking about here, is the support, where the support for the legislation comes from. It is the most diverse and comprehensive that I've seen in all the years that I've been doing the work that I'm doing. And that includes the courts have supported it, the state police have supported it, the Department of Corrections has supported it, and other entities that you really would not think of as being in the forefront of criminal justice reform. Not to mention my office has supported it, and many in the community. So there's only one entity that I know of that is opposed to it, and that is the Department of the Attorney General. We think that is a very unfortunate choice that they have made not to engage in that process, to say, let's work on this, let's come up with a finished product that addresses these issues.
What is their, the Attorney General's office, what is their position specifically, do you know?
Well, it is difficult to ascertain, I will tell you, because what we're talking about, there are at least 6 pieces of legislation that make up this package.
Right.
And each of them have a lot of moving parts. What we've seen is that they have selected certain portions of it and have exercised their right as they can. The Attorney General is a constitutional officer. By the way, I'll tell you, I have a tremendous amount of respect for Attorney General Kilmartin, but this is difficult to, it's difficult to tease out, I think, what the real reason is for their opposition to this. I'm not really sure. We've heard some, but not many specifics about that position. But in my opinion, I think it's something that if everybody sat down at the table, these could be worked out. But if you don't engage, you can't. So.
Well, let me ask Judge Clifton, what do you think? What's the best way to address this thing, and what would you advocate for specifically in terms of reform in the state of Rhode Island?
I think one of the biggest things that I would advocate for is the diversion, the ability to divert certain cases outside of the criminal justice system. In my over 20 years experience on the bench, I did not see that many people of color who were given the benefit of diversion. I don't know why. I mean, I have my own suspicions, but I haven't been able to confirm those suspicions. So I think one of the things that is being talked about, one of the bills that the Justice Reinvestment is proposing, is the expansion of the ability to divert cases out of the criminal justice system. And that would have huge benefits for those individuals who qualify for it. It gives the state the satisfaction of being able to assure that the person who is being considered for diversion is in fact the real type of person that they purport to be. There's a time frame by which the person has to successfully complete this in order to have the case diverted and removed from the criminal justice system. That's is it still 5 years, Michael, that is being discussed?
Well, there's discussion now about deferred sentences, which are kind of one form of diversion, but or deferred adjudication. And one of the most interesting parts of justice reinvestment, I think, is the diversion program that would be run by the Superior Court. So we have a diversion program in place right now. It is run by the Department of Attorney General. It is we have had clients successfully complete it, but not many. And I think it kind of begs the question too about, is it appropriate for a law enforcement agency, that is the Attorney General's office, to be the only show in town, so to speak? The model that this new diversion program would take would be similar to what we already have in place in Rhode Island with our drug court, which has been very successful. It's run by Magistrate John Flynn. Appropriate cases are diverted, and it's important to note that the Attorney General does have and should have input about the folks that go into that program and the folks who get kicked out of that program if it happens. But you know, the whole component, the whole driving force of this, while it might be monetary, we have the most people per capita, I think #2 in the country, of people on probation. And yet, you would think, with all those folks being supervised, you would think that we would have a low recidivism rate. And we don't. We have one of the highest.
Yep.
So if you step back and look at it, you say, well, maybe we ought to take a peek at this and see if we can do it better. And that's what justice reinvestment does. And what Judge Clifton was talking about is just one. It's a very important component of it, but there are others that are worthy of consideration, I think.
Yeah.
Well, I agree. You know, I spent a little bit of time in the public defender's office back in the early 2000s, doing outreach for then public defender Hardeman. And one of the issues that I spent a great deal of time with in the public sector is expungement. You know, one of the biggest problems we have with former clients of the ACI is employment. And of course that hinges often on the BCI, the record that person has. So expungement plays a major role, and I know that there are some bills on the Hill right now that are addressing that. What say you, Michael, on expungement?
Well, there are two important there are a number of expungement bills. I think the two most important are, coincidentally, one introduced at the request of my office and the other introduced at the request of the Attorney General. So the one introduced by my office would, what it would do is it would say for cases that are no longer criminal, but have since been decriminalized or reclassified as not as misdemeanors, but as civil violations. And the two most recent are suspended license cases and possession of small amounts of marijuana. It would give the court the discretion to go back and revisit those and then to expunge them if they meet the criteria. The other bill, which is that we like very much, and I'll give, you know, I don't want to be seen as, you know, dumping on the Attorney General, but this bill was introduced and by the Attorney General's office. This is now the third or fourth year that it's been introduced, and what it would do is it would allow the court to consider up to 5 misdemeanors, not felonies, misdemeanors, after a period of 10 years and to expunge those. There are carve-outs for offenses like drunk driving and domestic violence, as there should be. But that would afford a great deal of relief to folks who are, you know, have these cases sticking around. It prevents employment. It hinders housing. As you know, these are real impediments.
Absolutely. Judge Clifton, what's your opinion on the expungement issues?
I think it's sorely needed that we do that because, you know, sometimes we hear the maxim that it was a youthful indiscretion that people committed, and some people are able to get beyond those youthful indiscretion. We all, at one point in time, were youth, and I think you can't get to advanced age without going through your youth. So I think it's something that's sorely needed. One thing also I think that's it's not part of justice reinvestment, and I'm not saying it should have been, but the school to prison pipeline is one of the things that is of serious concern to a lot of people, and I think that needs to be addressed also. Our school systems have reached a point where too often children are disciplined in ways that I believe incites their motivation to be more disruptive, and which gets them to the point where they become when they leave school and the control that schools may have over them, they become prime targets for somebody who goes out and offends the community, gets a charge, and they become cycled into the prison. And it's very unfortunate to put this on young folks. The Supreme Court has recognized, rightfully so, I think, that the youthful brain is still going through the process of stretching out and becoming able to grasp these concepts. And so why don't we accept that and apply that to some of these young kids that we have saddled with these onerous responsibilities as treating them as adults when they're really not.
This is true. I know that one of the other issues that was very prevalent was the issue of violators and the impact that may have had, that tied into BCI records, that tied into all of this. And I think it was last session, Michael, that law was changed or revised for violators, that you had to be actually convicted of the violation before.
No, I think what you're thinking about is
The standard of proof.
yeah.
Yeah.
I think you're talking about two things. I think that's what you're doing.
Yes, yeah.
So a number of years ago, the General Assembly passed a law at our request that would, in very, very limited circumstances, allow a court to review a violation of probation if, and there are many predicates that would have to be satisfied, but so the charge that was being used to violate the person's probation, subsequent to the violation of probation, the person was found not guilty by a jury, or the case was dismissed for lack of probable cause, a no true bill was returned by the grand jury, and there are a couple of others. It would allow, in those limited circumstances, it would allow the court to go back and look at that finding a violation. There was a challenge to the law based on, among other things, separation of powers. And last April 2016, the Rhode Island Supreme Court, in a case called State versus Bodwin, that my office litigated, found that it was an appropriate exercise of authority by the legislature. More recently, as a result of some of these discussions about justice reinvestment, the court on its own did amend some of its rules. It's just about a year ago now, on probation and a couple of other things. The burden of proof was changed. There is a mechanism to revisit the length of probation, and these are great measures, but they're not comprehensive as the justice reinvestment package is. That is a comprehensive top-to-bottom reboot of the way in which we impose probation, administer probation, and treat probationers. So while the court took some steps in the right direction, we think that this legislative approach is the one that needs to happen.
You know, before we came on set, Judge Clifton and I were briefly talking about the issue of intake and the numbers of people that were in intake that were skewing numbers in terms of what the prison population was. And of course, this was one of the issues that drove that.
Right.
So, in our last few minutes, I guess this time goes by so quickly, and it's such a vast subject that we could talk about it all day long. But in the last few minutes, give me your ideas or your opinions on some out-of-the-box kinds of thinking that we should be looking at here in Rhode Island.
I would offer the consideration of what New Jersey has just done by eliminating financial bail for people who are charged with offenses. I don't know the number of people who are detained on a daily basis, on a snapshot basis, for lack of bail. But, for some people, coming up with $200, that they don't need for other purposes, is asking, it's impossible. But if they can't come up with $200 for bail, which it translates into $2,000 surety bail, where do they go? They're at the ACI, adding to the cost. So New Jersey has recently done that. A court in Houston, Texas, a federal court, has enjoined the Tarrant County from using the bail schedules, because what that court found, for example, was that the bail that was being imposed on people resulted in the overwhelming numbers of poor people being incarcerated for small de minimis offenses. So I think we should perhaps consider doing away with cash bail.
Mike, do you have anything out of the box that you want to offer?
I'm just going to work off of what Judge Clifton said, if you don't mind, Judge.
Right ahead. It's not the first time.
Judge Clifton's absolutely correct that I don't think it's too early to say that this is a trend in the law that may be getting some traction. We've been monitoring three federal cases in the trial courts involving the constitutionality of monetary condition bail. I think they're all in the South. I could be wrong about that. And in each of the three, what's interesting about them in my mind is that in each of the three cases, the Department of Justice under the Obama administration filed what's called a statement of interest, basically saying what Judge Clifton just said, which if you stop and think about it, it's pretty extraordinary that you have the preeminent law enforcement agency in the United States saying that, this monetary bail stuff is really a bad idea. And the research shows that. There's work that's been done by the Pretrial Justice Institute showing that, folks who are detained on bail tend to reoffend once they're released, that the disruption is a major factor in that. And there's quite a bit out there, and that is even to the point where folks who are detained end up, for the same set of facts, receive longer sentences than folks who aren't detained. Wow. Some of this came out of Justice Reinvestment. Other organizations have done the work on this too. So.
Okay. Well, gentlemen, listen, we've run out of time, believe it or not. A half hour goes by very quickly when you're having fun. But I want to thank today's guests, Judge Clifton.
Thank you.
And Attorney DiLauro.
Thank you, Peter.
And you, the viewers, for tuning in to another segment of Another Opinion. A special thanks to Rhode Island PBS for making this program possible. I'm your host, Peter Wells. Follow us on Facebook and Twitter at inanotheropinion@gmail.com. And have a great day.
The Rhode Island Foundation, partnering with passionate Rhode Islanders to lead, transform, and inspire our state. Learn more at rhodeislandfoundation.org.